I have 3 kids, a boy and girl twins, which really makes my presence here a little more amazing because I don't know where I found the time to really, in that time, come up with a statement. But I thank you for taking the time to listen. In addition, I'm also in Arkansas to think about as well. But as Representative Burris has repeatedly said, and as an instructor, when we're out there teaching classes and speaking with the other instructors, individuals in the class leave that class when we have the law discussion with as much fear from the law itself as from the perpetrator there in the class there to protect you so strong. And I think you guys would agree that there's something wrong with that. We need to do something because these are citizens of this state trying to do their good for the community and themselves. And what they're afraid of is that immense discretionary powers of that prosecuting attorney, not remembering that they were the law-abiding citizen who, by no fault of their own, were thrown into that split-second situation where their life, the life of their child, or the life of an innocent stranger was placed in that imminent danger. But unlike the 15 states that have recently passed the Castle Doctrine law, and many of these are actually a stand your ground law, but many of these states did not even have Castle Doctrine law. And that's not the case here in Arkansas. As Representative Burris has referenced, Statute 5-2-620, and we have talked about it, but I think for everybody's edification, to actually read it is very important. It follows that it is titled Use of Force to Defend Persons and Property Within the Home. A, the right of an individual to defend himself or herself in the life of a person or property in the individual's home against harm, injury, or loss by a person unlawfully entering, attempting to enter, or intrude the home is reaffirmed as a fundamental right to be preserved and promoted as public policy in this state. There is a legal presumption that any force or means used to accomplish a person or a purpose described above was exercised in a lawful and necessary manner unless that presumption is overcome by clear and convincing evidence to the contrary. It currently stands in law that those normal police investigations and processes always occur. And in those 25 years, and in the research I have done, I have not found this to be a law to be hidden behind by criminals who are wishing to hide their murderous acts or by individuals looking to set up their friend or their neighbor. It has been used very prudently by not just concealed carry holders. This covers all citizens here in Arkansas. And the House bill before you today simply extends this public policy to protect concealed carry holders outside of their home. And why do I make that statement? Because outside of the home, the only people who have the ability to carry a firearm are concealed carry holders and law enforcement officers. Okay, law enforcement officers, as previously stated in the law, have no duty to retrieve, but concealed carry holders do. And according to the Cato Institute, as Mr. Burris said, 87% of all crimes, violent crimes, are committed outside of the household. In fact, of the 2.5 million times citizens of the United States defend themselves with firearms every year, 2/3 of those occur outside of the home. Now, there are many states that don't have concealed carry policies. Vermont, for one, where anybody can carry. But for those states like us here in Arkansas, we do require a concealed carry license. This law would be used almost exclusively by those individuals. Now, let's take a look at concealed carry holders, because really this bill comes down to these individuals. There was a study done in Texas in 2000. Actually, it wasn't done by Texas. It was done by the National Center for Policy Analysis. And they conducted a study of all Texas concealed carry revocation rates in the year 2000 up to that date. And what they found were Texas concealed carry holders proved to be 5.7 times less likely to commit a violent felony and 14 times less likely to commit a non-violent offense. I recently received from the state police headquarters the yearly number of revocations for all Arkansas licensees since our law was put into effect 12 years ago. About 61,000 of us currently carry here in Arkansas. For all the offenses that would lead to a revocation, just like that was applied in Texas, our licensees were shown to be almost 300% more law-abiding than Texans. Ours were 300% more less. If you take that out times the 5.7 or the 14, our concealed carry holders are extremely prudent in their actions, not just in the use of their firearms, but in their daily lives. I also extrapolated that the violent crime for those individuals, with the help of the state police department, and here's just a mix. I'm not going to go through all 12 years. You have better than to listen to me go through that. But I'll do the last three. In 2004, out of 51,000 average licensees, we had 5 violent offenses by them. 2005, we had 3, and there was 54,000. And in 2006, last year, we had 1 violent crime out of all those individuals, and an average of 57,000 licensees. To put this into just a little bit of perspective, the U.S. Department of Justice in 2005, the most current numbers we have, put the violent crime rate for the United States, which was a 40-year all-time low that I'm sure we all are aware of, at 21 violent crimes per 100,000 in the population. If you extrapolate our rate, it comes out to about 0.1 in 2004, 0.06 in 2005, and 0.02 in 2006, or 1,000 times less the average citizen in the United States. I think you can agree with me that's pretty compelling. And what I want to emphasize is that it is this population of Arkansas concealed carry holders, who are probably the most law-abiding subset of society on this planet, except for maybe Vatican City, but they will be the ones who are going to be subject to that 87% of all violent crime that Arkansas experiences next year. They are the ones who are going to be responsible for 2/3 of all those defensive gun uses. And it is this population of concealed carry holders that will almost all exclusively utilize and benefit from this law. I guess the question before you here today is, can we trust these licensees? It comes down to a question of trust. There is no way we're going to get rid of every possible situation, but I trust the police to do their job. I trust the individuals out there to act prudently. And I think that in lieu of the 25 years experience we currently have with immunity and with our own castle doctrine, and a lack of abuse of that we can say absolutely yes, in light of this data, to our own concealed carry holders. 15 other states have said yes, with not nearly the compelling evidence that we have for our own population. And I ask today that you also give that vote of confidence as well. Thank you.
Thank you, Mr. Hayes. Next on the list to speak against the bill is Bob McMahon. Mr. McMahon, state your name for the committee.
Bob McMahon, prosecutor coordinator representing the Prosecutors Association.
You're recognized.
Thank you, Mr. Chairman, members of the committee. What I want to talk to you today is, and I'm going to be very, very brief. I have some prosecuting attorneys with me today that's going to talk about specific cases that this law would affect. I wanted to cover a few general things. Many of our concerns with the Prosecutors Association we have addressed here today. I'm going to go over some of those just so you know what our positions specifically are. The main thing that concerns us about this bill are many unintended consequences. We understand what the bill is intended to get at, but it is those unintended consequences that concern us. Again, many of you pointed those out today. Current law in the opinion of the Prosecuting Attorneys Association